The Truth and Reconciliation Commission's report on residential schools isn't the only finding that's shaking up Aboriginal relations in this country. In today's State of the Nation, we examine a recent ban decision and court rulings that are redefining Aboriginal rights with one of Canada's leading Aboriginal lawyers, Pam Palmater. In May, BC's Lax-Kw'alaams First Nation rejected Pacific Northwest LNG's proposal to build a coastal LNG terminal near Lalou Island. That was because of environmental concerns. Last June, the Supreme Court of Canada ruled that BC's Tsilhqot'in First Nation had title to traditional hunting lands without proving its entitlement through official land titles. Pam Palmater is a lawyer and chair of Indigenous governance at Ryerson University. Great to have you with us.
Thank you.
So let's start with, I actually want to start with the second one, the Supreme Court ruling, because it seemed to me, it felt at the time, and I think people would say, that's a game changer. That's a new era of Indigenous rights to title the very land under our feet. What does it mean? We know what it means for that particular band, but what does it mean in a broader way, Pam?
Well, you're really getting clarification on what is Aboriginal title. It's not just about hunting and fishing, and I think the majority of the provinces and territories have worked very hard to kind of limit it to just how you use the land. And the Supreme Court of Canada in Tsilhqot'in was very clear. It's about ownership, it's about a veto, it's about the right to decide what happens on your territory and what doesn't, and to get all of the benefit from it if you choose to extract natural resources. But it's also the right to say no, because it's not just looked at in terms of an economic interest. It's also about the entire basis of Indigenous sovereignty, Indigenous governance, and identity for Indigenous people.
So presumably this opens the door to many other such cases. Is there a piece of land in Canada that wouldn't then be handed over, the title of which wouldn't be handed over to some First Nation or other?
Yeah, well, keep in mind that the entire territory in Canada all belong to Indigenous nations. The question or the battle now that'll happen in the courts is whether or not the title to those lands were ceded or surrendered, either under an early treaty or under a land claims process. You've got large areas, like in the Maritimes where I'm from, where the Mi'kmaq Nation had never ceded or surrendered any of their lands under their treaties, and in fact have always claimed Aboriginal title over that area. And think that's the majority of New Brunswick, Nova Scotia, PEI, parts of Newfoundland, Quebec, and Maine. I mean, these are giant areas, and it'll be the same for large parts of BC, for example.
And so what is the practical outcome of that? I know the immediate aftermath outcome has been newfound power, newfound respect for the rights of First Nations, Aboriginals, and therefore a negotiation. But if, for instance, the Atlantic provinces go to the Mi'kmaq, what does it mean? Would you anticipate there would be financial settlement? Would there actually be a change in how the land is used?
Well, I think you have to think about the land not just in economic terms. So it's the core of our sovereignty. So the ability of Indigenous peoples to just say no. No, there won't be a pipeline. No, there won't be tar sands. No, there won't be mining or hydrofracking or whatever it is that has the potential to destroy lands in the future. Now, we've always had that right. What Tsilhqot'in does is say now it's legally recognized and federal and provincial governments can't do away with that. So I suspect that for many First Nations, they're not going to be sitting down at the table saying, how much money are you going to compensate us? It's going to be about them wanting to manage their own territory, manage their own resources, and decide when and if and how many benefits they get. Other First Nations may settle for compensation, but I think what you're seeing now is a recognition that you can't replace land. That if you're going to be sovereign, if you're going to be your own government, you actually have to have a territorial land base, and a land claim for money isn't going to do that, and Tsilhqot'in supports that.
And so we also mentioned Lax-Kw'alaam and the negotiations around LNG. It feels as though, again, there's a new kind of way of thinking about negotiating with Indigenous peoples. And in that case, of course, an exercise of rights and power. Is this a good new era, a positive new era in terms of the relationship between business and First Nations?
It actually is really positive, because what we were limited to before was very government paternalistic kind of land claims process that dug on for 30, 40, 50 years, and you're really talking beads and trinkets. You're talking a little bit of impact benefits, whereas now the whole game has changed. We're talking about ownership and consent, and that actually provides far more certainty in terms of markets and the business and the economy, because now you know who to go to, who you need to talk to, and that's First Nations. And First Nations are more than willing to talk partnerships and sharing and jointly managing resources. And businesses seem to be open to that. The problem has always been federal and provincial governments as this mediator who weren't interested in any of that stuff. So if we get rid of that middle person, now we can deal directly with our partners, and that's exactly what the treaties envisioned.
All right, and Pam, I got to ask you, we've been talking today, as everybody has, about the Truth and Reconciliation Commission. That married with the Supreme Court decision, just give me your reflection on kind of, is it a new era? Can we actually call this sort of a turning of the page in the relationship and a brighter one?
Yeah, I think so, because really what the Truth and Reconciliation report and all of the reports on murdered and missing women and child and family services show is that when government is in charge of managing the lives of people from birth to death, they do horribly at it. And so when you take out that factor, the Minister of Indian Affairs or whomever it is, and you leave it up to First Nations, we've always managed it well before. We had good treaty relationships with Canadians, and now this is about what we're going to go back to. The direct relationship between First Nations and Canadians, leaving the kind of interloping, meddling government people out of it.
All right, great to have you with us for this.
Thank you.
Pam Palmater is Chair of Indigenous Governance at Ryerson University.